Good day and welcome back to the law offices of Mark Martinez. I'm Mark Martinez, and today we're going to go over how to testify in court. I think this is a big subject and something that the common man could use. So you found yourself in a lawsuit, and that's never a fun thing. And today we're going to go over how you can testify to best protect your legal interests in a lawsuit. So I have five basic steps on how we can go through this and answer questions. And this is going to give you a foundation on how to testify in court. Before we go into these 5 steps, let's talk about what testimony actually is. Testimony, what I'm talking about, is when you're going to be speaking under oath. That's a lot different than you and I having a conversation, or even you and your attorney having a conversation. This is going to be documented either in a deposition, an arbitration, or live in court. And so these 5 foundations, these 5 steps will help you and answer those questions. Step number 1, make sure you heard the question before you answer the question. Very simple. Make sure you heard the question before you answer the question. And what that means is to make sure that you heard everything that was said to you. If you don't hear everything that was said, then the correct answer is, "Excuse me, Your Honor, I didn't hear. Can you repeat?" Or, "Excuse me, counsel, I didn't hear. Can you repeat?" The second step is to make sure you understand the question. Make sure you understand the question before you answer the question. And make sure you understand the question generally, and make sure you understand every single specific word in the question. Question: did you drive in a car to the court today? Yes. Did you drive to the court in a red car today? No. I just asked myself 2 questions. The only difference was 1 word, the color red. And this is a good example of attorneys, perhaps you're nervous, or attorneys using very complicated language that you don't understand a specific word in the question. And if you don't understand a specific word in the question, you don't want to guess. And so here I use a very easy example where the general question is, did you drive to the court today? The answer is yes, versus a more specific question, did you drive to the court in a red car? And then that yes turns into a no. Imagine if you didn't know what the word red meant. Now you've just messed up your answer. And it looks very poor when you have to go back and change an answer in testimony. That shows inconsistency, and being inconsistent too many times sometimes shows that somebody is being untruthful, or can be interpreted that somebody is being untruthful. So that is the second step, is to make sure you understand the question, the general question, and to make sure you understand every single word in the question. If you don't understand the entire question, either generally or specifically, again, the correct answer is, "Excuse me, I didn't understand. Can you repeat the question?" And then the attorney, the judge, whoever is asking the question, it's their obligation to try to frame that in a way that you understand. In addition, this can be something where it's a long-winded question. Isn't it true, Mr. Martinez, that on June 14th, 2020, you were at the corner of Broadway and Main and you were looking at a red crosswalk or a red stop sign, and you continued to walk across the street? Is that true or not? This is a long-winded question. There's a lot of questions within the question, very complicated. If you really can't answer the question, sometimes the correct answer is, "Excuse me, I don't quite understand that. Can you repeat the question?" And this is to simplify it, to make it in a way where you can actually answer the question and you're not trying to get tricked or manipulated or trapped in a situation. Finally, not understanding the question also shows that this is not the time to act smart or act intelligent. This is the time to truthfully testify about what happened and what you recall. And in doing that, you want to have these questions presented to you in a very basic and simple way where you're able to testify about the truth and about what happened. So in reviewing the first two steps, the first step is to make sure you heard the question before you answer the question. The second step is to make sure you understand the question before you answer the question. The third step is to make sure you know the answer before you say the answer. And what this means is just that you're thinking before you speak. Again, testimony, we don't want to be inconsistent. So before we open our mouths, we want to know what's coming out. This isn't on the street where we're just talking and the first thing that pops into our head is the first thing out of our mouth. So the third step is to make sure you know the answer before you say the answer, using my 4 favorite answers: yes, no, I don't know, I don't recall. When can you use yes or no? You can use yes or no when you know something with 100% certainty. Mr. Martinez, are you a man? Yes. Mr. Martinez, are you a woman? No. These are 2 questions where I don't have to think about the answer. I know with 100% certainty what the answer is. Mr. Martinez, what time did you wake up this morning? Well, I wasn't looking at my watch, so I think it was around 6 o'clock because it was before the sun was up. Sometimes we don't know what the exact answer is, so we can't use these short answers. We got to give an estimate or an approximation. And what I suggest in these situations is you qualify the answer. And qualifying the answer is what I just did there, is using a word, a statement, a phrase, saying that you're not 100% sure what occurred. And so as far as the question of what time did you wake up, I qualified my answer. I basically said I didn't really know because I wasn't looking at my watch when I woke up, or I didn't have an alarm on this morning, things like that. When you can use yes or no, it's best to use yes or no, depending on who's asking the question. We'll get into that in a little bit. I don't know, I don't recall. What time did my mother wake up today? I don't know. And the reason why I don't know is I don't live with my mother. So I have no idea what time she woke up today. Sometimes you'll be asked questions that you really don't know the answer to, and the correct answer is I don't know. What time did I wake up 37 days ago? I don't recall. I was there when I woke up 37 days ago, but if I'm asked on the spot right now, I probably can't even get a real guess out or a real estimate out unless I'm going to get in front of a calendar or something. But in real testimony, there's no way that I'm really going to know that answer. And so the correct answer in that situation would be I don't recall. So that's step number 3, is make sure you know the answer before you say the answer, using my 4 favorite answers: yes, no, I don't know, I don't recall. And then if you have to give an estimate or an approximation, you want to qualify the answer. You want to use qualifying language. Approximately. Well, I'm not sure exactly, but, this is important usually when you're talking about physical locations that you may not be sure of, dates that you may not be sure of, times that you may not be sure of. So make sure that you qualify your answer in those situations. Why? Testimony is different than regular conversation. Testimony is literal. And what I mean by that is if you say that you crossed the street, then you crossed the street. If you say you crossed the street at 6 o'clock, that means you didn't cross it at 6:05, you didn't cross it at 5:59, you didn't cross it at 6:01. And this is how some cases are won and lost on the minutia, the details. So you want to be as concise as possible when you're testifying. The fourth step is make sure you focus on the question before you answer the question. Make sure you focus on the question before you answer the question. Did you drive to the court? Did you drive a car to the court today? Sometimes I'll ask this to my clients and their answer is Yeah, well, I got there. It took a while, but yes, I drove in the car. There was a lot of traffic. I had to find a parking meter. Be careful with these types of answers. And the reason why is the question was, did you drive to the court in a car? The answer is a yes or no answer. There is no, can you also give me an explanation of why you did something? So you want to really focus on what the question is trying to ask you, trying to elicit. And in certain situations, you don't really want to give an explanation. And the reason for that is it's going to be long-winded testimony. And if you're being asked that by an opposing counsel, there's a chance that they can see some of that information and use it against you. Also, there's a chance that if you're not testifying in a concise manner, the judge is going to grow impatient. Remember, the judges are overburdened. They have, several hundred to 1,000 cases right now. So they're really focused in and honed in on testifying. Also, you just really want to pay attention to what the individual is asking you, whether it's the opposing counsel, whether it's your attorney, whether it's the judge. So that would be step number 4, is to make sure you focus on the question before you answer the question. In reviewing the steps thus far, we have step number 1. Step number 1 is make sure you heard the question before you answer the question. Step number 2 is to make sure you understand the question before you answer the question. Understand generally and specifically. Step number 3 is to make sure you know the answer before you say the answer, using my 4 favorite answers: yes, no, I don't know, and I don't recall. Step number 4 is make sure you focus on the question and answer the question only. And then step number 5, understand who is asking the question. Understand who is asking the question. And what I mean by that is there's 3 general players that are going to be asking you questions when you're testifying: your attorney, the opposing counsel, the other attorney, and the judge may chime in and ask you specific questions. When your attorney is asking you questions, you can put your guard down a little bit. You can concentrate on the theme of your case and start elaborating and testifying a little bit. Well, what time did you, let me think of something, but let's say your theme is that you got double-crossed by the other party, and it was their fault that you did something. So, for example, well, did you sign that document? Well, yes, I signed, but Charlie was the one who kept insisting that I did. If your attorney is asking it, whenever you can, try to plug in your theme with testimony whenever you have the opportunity. Repetition, I believe, is key in consistency and in plugging in what your theme is. You and your attorney can agree on what kind of theme you have to a case. And what I mean by theme is, well, what is this case about? How are you going to win? How is the other side going to lose this case? And you want to plan that out before you get into court. If the judge is asking you a question, well, you better be focused and you better pay attention to the question. Why? Because most of the time this is an important question, especially if the judge is deciding the case. If this is a jury trial, maybe not so important, but if this is a bench trial where the judge is deciding, well, this is an important question, and just make sure that you answer it as thoroughly as possible, and yet at the same time, don't go off on a tangent because the judge is not trying to look for other information. They want the answer to a question and to help them in getting some information about the case. The third person that will ask you questions would be the opposing counsel. Now, the opposing counsel is trying to defeat you. They're an adversary. They're not trying to help you. They may act like they're being nice. They may act like they're there just to do a job, but they're there to zealously represent their client and win, just like your attorney. And so usually you want to stick to the foundations that I've laid out and answer the questions in those manners and not really elaborate too much. Recall that when you're being asked by opposing counsel questions, if you answer them incorrectly, or if there's some type of question you don't answer to the best of your ability, your attorney can always do what's called redirect and ask you questions after the other side has asked you questions. So typically what I tell my clients is, hey, when the other side is doing cross-examination, answer the questions and wait for the next question. But just remember that if you don't answer the question to the best of your ability, don't worry about it. Just move on to the next one. And then I'll have an opportunity to go back and redirect or ask you questions after the other side is done. And that would be a little bit safer way where you can rehabilitate some of that testimony. So those are my 5 steps in answering testimony, in testifying in court or in a deposition or arbitration or wherever you may find yourself. It's a tense situation. The spotlight is on you. And now you have a toolkit. And this is extremely helpful because most individuals are not repeat players in the system. They've never testified before. They've never been in a deposition before. They don't know what's going on. And so now you have a toolkit. Sometimes the best answer is no. A lot of people think that they need to give all kinds of information when they are asked a question. They need to know the answers. They need to look smart. They need to be like somebody on TV where they're trying to confess, all this stuff. But really, you have a toolkit now. Sometimes you can say what your theme is going to be. You can plug in. You can strategize what your answers are going to be. I don't recall. I believe it was 6 a.m. Yes. I don't recall. So this is a way where now you have some ammunition and you can feel a little bit more confident testifying in court. So just to repeat the 5 steps in testimony, the first step is to make sure that you heard the question before you answer the question, because you're testifying. You don't want to have inconsistent testimony. The second one is to make sure you understand the question before you answer the question. The third step is to make sure you know the answer before you say the answer, using my 4 favorite answers: yes, no, I don't know, I don't recall. Step number 4 is to make sure you focus on the question and answer the question. Step number 5, know who's asking the question. Thanks a lot, and I wish you the best of luck.